don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, you know? So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
90-day program.
Yeah. Ms. Young, in cause number 24, DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the second-degree felony offense of assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
Sure.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
True.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand that?
Yeah.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yeah.
And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
No.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, you know? So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
90-day program.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff. I just took care of that other stuff that you filed.
Oh, thanks. Sorry, it took a minute.
That's okay. It's done now. It's all good. And
I got a phone call and I said it's in the air right now.
yes. Good morning. Are you Travis Smith? And Mr. Smith was previously in court, entered a plea of guilty to theft of property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, Your Honor.
I have, Judge.
Are there any additions or corrections?
No, well,
One thing is, it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out, and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here, so he has. They're in the courtroom. He has strong family support,
Okay,
a lot stronger than what that says.
good. Thank you.
Uh,
I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking medicine in jail?
Okay.
I don't think so, Jan.
Okay,
But I'd have to be a psychiatrist to truthfully answer it,
Okay.
correctly answer it.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I was
thank you.
gonna say.
All right, so
Yeah,
they'll get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Honor. He'll be released today.
He should be,
Yeah.
yeah, as long as there's no other hold that misdemeanor, once if there's nothing else in the other county. But if it's just this, yeah, you should be released today, and you'll get some instructions today before you leave the courtroom from probation to tell you exactly what to do when you're released, okay? Okay,
Thank you, Honor.
yes, sir. Ms. DeLage, you have Jeremy Alexander.
Yes, Your Honor.
Good morning.
Good morning. Rainy morning.
Yeah,
That was a lot of.
very
fun
rainy,
walking.
a lot. Morning. Good morning, sir. You Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly or disabled individual. And what is the announcement?
Your Honor, we're gonna ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm gonna double check.
Okay, so if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Mr. Lage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay, you go back with the bailiff.
Just. Thank you.
Thank you, ma'am. I could just put a notation, videos specifically, yeah. Brian McWade and Mr. Macon.
Good morning, Your Honor.
Good morning.
Sorry.
Yeah. Good morning, sir. You Brian McWade?
Yes, ma'am.
And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was time.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right. I
April
usually
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence. Other than that, it's just a matter of if the case is going to go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Utron, right? As an electrician.
Okay. Ms. Malfino,
Judge,
does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. If you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. If the court has already heard this, I'm sure my position will be the same as Mr. Coleman's originally was.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning, but we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that